The clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
We'll hear argument first this morning in 20-158, Draughon versus Johnson from Kaufman County and the 5th Court of Appeals District.
May it please the court, Mr. McGuire and Ms. Alexander will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal. Mr. McGuire will open with the first 15 minutes and Ms. Alexander will present the rebuttal.
Good morning, Justices. May it please the court. My name is Dan McGuire, and I will be presenting argument on behalf of the petitioner, Rodney Draughon. As the clerk said, my co-counsel, Latoya Alexander, will be presenting argument and rebuttal. Thank you for the opportunity to present this case to you this morning. This matter involves a fundamental question of law. What are the evidentiary burdens when a party files a motion for summary judgment exclusively based on the statute of limitations, and the non-movement has raised the unsound mind tolling provision under section 16.001A2 of the Texas Civil Practice and Remedies Code? As this court recognized in Ruiz v. Conoco, the unsound mind tolling provision reflects a, quote, considered legislative judgment that in enumerated circumstances, the strong policy in favor of prompt disposition of disputes must give way to the need to protect a plaintiff who is unable to protect himself or herself. We are here today because the various courts of appeals have inconsistently applied the summary judgment burdens with respect to the unsound mind tolling provision, leaving these vulnerable litigants adrift and without guidance. We are asking this court to apply its clear precedent and specifically articulate that at the summary judgment stage, the movement bears the burden to conclusively establish a defense of limitations and must negate any tolling provisions raised by the non-movement.
The burden is different at trial?
Correct. Yes, Your Honor. The burden at trial is obviously different, and that different burden, or the different burdens between trial and at summary judgment, was recognized by this court in Woods. And so the burden that we're discussing today is specifically and exclusively related to summary judgment burdens. So at trial, of course, a party asserting unsound mind must present evidence and secure findings of fact to support that plea. However, at the summary judgment stage, it is the movement who is seeking summary judgment based on limitations who must negate unsound mind. Briefly, by way of background in this case, this is a real estate dispute in which the respondent, Joycie Johnson, who is Mr. Drone's aunt, induced him to sign a deed selling his lifelong home to her for $10. And Mr. Drone is an adult man in his 40s with severe mental disabilities and limitations that have significantly impaired his ability to lead a normal life. He cannot care for himself, and he relies upon friends and family to perform many activities of daily living. The deed at issue in this case was signed in 2006, and Mr. Drone continued to live on the property until March 2018, when Ms. Johnson evicted him. And with the assistance of a pro bono attorney, Mr. Drone initiated this lawsuit against Respondent in April 2018, contending that the deed was invalid because Mr. Drone lacked mental capacity at the time the deed was executed. Now, in the trial court, the respondent asserted that the claim was barred by the statute of limitations, and she filed a motion for summary judgment exclusively on that basis. And the respondent did not present any summary judgment evidence other than the signed deed, and did not address the unsound mind provision whatsoever or Mr. Drone's mental capacity. Now, in response to the motion for summary judgment, Mr. Drone again contended that he was mentally incompetent and under a legal disability, specifically that he was of unsound mind at the time the deed was executed, which would operate to toll the statute of limitations under section 16.001A2. And both the trial court and the Fifth Court of Appeals below erroneously placed the burden of proof on Mr. Draughon as the non-movement, rather than requiring the respondent as the movement to negate the unsound mind tolling provision.
What was the burden that they placed on him?
To effectively present summary judgment evidence that would create a fact issue as to unsound mind, Your Honor. And of course, we're all familiar with ordinary summary judgment burdens. But in this particular case, because we're talking about this specific issue involving the statute of limitations, when a party moves for summary judgment on that basis, this court's precedent is clear that the party seeking summary judgment must not only establish the statute of limitations defense, but they must also negate any tolling provisions that are raised by the non-movement. And this rule has been reflected in this court's prior decisions for decades, including Woods v. William M. Mercer, Diaz v. Westfall, Jennings v. Burgess, KPMG v. Harrison County Housing Finance Corp. And in all of these cases, this court held that the summary judgment movement carried the burden at the summary judgment stage to negate any tolling provisions that were raised.
So if he can't even raise a fact issue, why should he get to go to trial?
Well, Your Honor, we believe that this court's precedent establishes that the assertion by the plaintiff that he was of unsound mind is sufficient, at least again at the summary judgment stage, to require the movement to disprove it. And so, for instance, it's effectively the same argument that we believe is applicable to the discovery rule. And that's why we have, again, this court has not specifically addressed the unsound mind tolling provision, but this court has time and time again addressed the discovery rule, in which the plaintiff alleges that he or she was unable to determine that they had a cause of action. And so in that instance, the court has had no concerns about allowing that assertion alone to withstand summary judgment if the movement who is trying to get summary judgment cannot negate the discovery rule. And so in this instance, we believe that the unsound mind tolling provision is identical in that sense. And again, of course, the trial burden is going to be different than the summary judgment burden, but the assertion alone of the unsound mind tolling provision under this court's precedent is sufficient to withstand summary judgment.
So can a
Mr. McGuire,
Mr. McGuire, can a defendant never rely on a 166A(I) no evidence motion for summary judgment to challenge a plaintiff's assertion of the discovery rule? Is there case law on that point?
Your Honor, we have found case law, and we are aware of case law in which a defendant could file a no evidence motion for summary judgment as to the discovery rule. So it's my understanding that that is a procedural mechanism that a defendant can use to attempt to require the plaintiff to present evidence to support the assertion of the discovery rule. However, of course, in this case, it was not a no evidence motion for summary judgment. It was a traditional motion for summary judgment in which the defendant carried the burden to negate any tolling provisions.
So if the plaintiff in this case had filed a no evidence motion for summary judgment on unsound mind, then you wouldn't be here today. You would have borne the burden of putting on some evidence to avoid summary judgment?
Your Honor, that's our understanding. Yes, sir.
So this is just a procedural question. It's really not, however we answer this case then is going to solve the problem that you're saying exists out there, because if we agree with you, then nothing changes going forward, because in the future, all defendants will know to file a no evidence motion for summary judgment instead of a traditional motion for summary judgment.
Your Honor, that certainly is a possibility. However, I think the reason why this is important here and why we're asking the court to clarify the issues in this instance is because the very nature of a no evidence motion for summary judgment, if it's filed against a plaintiff, specifically, in its name alone, suggests to the plaintiff what their burden actually is. Under the traditional summary judgment standard, which was applied and which is at issue in this case, that's where the burdens became confused. And so in this So we're asking the court to clarify the burdens. And so we believe that this court should obviously reverse the fifth court below and remand this case back for trial. And if the respondent, as the defendant, wants to actually file a no evidence motion for summary judgment, then certainly Mr. Draughon, as the plaintiff in that case, will have to present evidence to support it. But at least the burdens are clear. And in this case, we don't believe that the courts of appeals below have clarified this standard with respect to unsound mind sufficient to give litigants notice of what evidentiary burden they actually do carry based on the different types of summary judgment motions that are available.
Was the burden unclear here where your client did put forward summary judgment evidence and the trial court struck that evidence, but he offered 6 affidavits. I don't think we have a challenge in this court to that ruling.
Yeah, correct, Your Honor. It is true that Mr. Draughon in the trial court did, or his counsel did attempt to submit affidavits that were struck by the court. I don't believe that reflects a confusion about the burdens, because as we all know, very often, even when a party does not have a burden of proof at summary judgment, because that operates so harshly to cut off the plaintiff's claim, oftentimes the plaintiff, even when he or she does not have the burden, will, just as a matter of course to ensure that the summary judgment is going to be denied, submit summary judgment evidence. So we don't believe that the fact that Mr. Draughon submitted the evidence alone indicates that there was not confusion as to the burdens. And I believe actually, I do believe that there was a discussion in the trial court with Mr. Draughon's counsel in which he did acknowledge that he thought maybe that they didn't have the burden, but they were presenting the affidavits anyway. We believe that this court's precedent with respect to the summary judgment burden is clear. And I will say that I don't think the respondent has really provided any rationale, certainly no precedent, by which this court can hold that the unsound mind tolling provision should not be at least considered in the same category as the discovery rule, because both are of the same nature, and both of these tolling provisions, the discovery rule and unsound mind, are certainly different than other types of responses to a statute of limitations argument, such as fraudulent concealment or estoppel. And we believe that this court's prior precedent actually does make that distinction. However, and for instance, in Orem clearly recognized a difference between tolling provisions that might apply, in which the summary judgment movement bore the burden, compared to a situation in which the plaintiff argues that the defendant is estopped from arguing that the statute of limitations applies. And so Orem, for instance, in that case, did say that in the first instance, when you're just talking about a tolling provision, it is the movement's burden to negate that tolling provision. But when a plaintiff is arguing that the defendant is estopped from asserting the statute of limitations, that's when the burden is on the plaintiff to present evidence in support of that estoppel argument. So we believe that the nature even of unsound mind is certainly in the same category as the discovery rule, should be subject to the same summary judgment burdens with respect to a traditional motion for summary judgment. And I should also mention, yesterday we had a chance to provide the court with a notice of supplemental authority. The First District Court of Appeals in Houston, just on February 25th, and we only recently became aware of this case, but the First District Court of Appeals reached a decision in a case called Rollins v. Pressler, analyzing this exact same issue. And in that case, the First District Court of Appeals held that it was, again, the movement's burden to negate unsound mind. So that is some additional and more recent authority that the First District Court of Appeals has provided to support our argument in this case. And so we believe, and we would ask this court to engage in a similar argument, similar analysis, and reach the same conclusion. At this point, thank you very much for your time this morning. I'll reserve the rest of my time for rebuttal.
Any other questions? Thank you, Mr. McGuire. We'll hear from the respondent.
May it please the court, Mr. Monning will present argument for respondent.
court please, the idea that the defendant would have to prove that the plaintiff had a sound mind all the time that the statute of limitations was running, even if you were working on a clear slate, is an extremely bad idea. In my practice, which is small firm litigation and has been for a long time, I can only imagine how that meeting with the client would play out. They would come in, and just taking this case as an example, something happened more than 10 years ago, and the client comes in and says, I've been sued for this. Isn't there something in the law that says after a while, it's just too late to bring a suit? And you say, yes. Of course there is. There's statutes of limitations. Then you look at, and perhaps we can do something about it, because on its face, it looks like they're barred. If you look at their pleading and under the argument that petitioners seeking, if they put the magic words in there that the petitioner, the plaintiff, is of unsound mind, that casts on the defendant the burden of proving, of finding witnesses that can swear to clear, positive, uncontradicted facts according to the standard of Rule 166 in order to get a summary judgment.
Mr.
Go ahead, Justice Lerman.
Thank you. Isn't the let's say, for example, if in fact they would have put on enough evidence to defeat or to bring up a fact issue, then for you, because we're at the summary judgment phase, we're not on the merits, you would have to do that anyway, right?
I would have to put on evidence of their soundness of mind.
You would, if they just put a mere amount of evidence in that the trial court found was sufficient to create a fact issue, for you to get the case dismissed on summary judgment, you would have to do exactly what you're saying now anyway, right?
Well, I'm not sure if they put on probative evidence that of unsound mind, I'm not sure I could get a summary judgment based on limitations. All I would have would be the presumption that exists across the law that people generally are of sound mind. And that's one of the fallacies of their argument. They're asking in this context for the court to assume just based on naked pleadings that a plaintiff is of unsound mind. And
Mr. Monning, we said last term in Erickson versus Renda that in the summary judgment context, a defendant must conclusively negate the application of the discovery rule and any tolling doctrines pleaded as an exception to limitations. There we were dealing with Hughes tolling, which is a common law exception. Here we have a statutory exception. So doesn't Erickson really answer the question that's before us here?
well, Your Honor, I'm not sure that it does. If you look at Erickson, I had overlooked that case until the papers that petitioner filed last night. And in the Pressler case, clearly they relied on Erickson as their foundation. If you read Erickson, you will see that Erickson does contain the language that petitioner is urging. That is, the defendant has to negate all applicable tolling provisions. The court cited for that proposition the cases of Jennings v. Burgess and Diaz that were from the 90s. If you move back a couple of years earlier in 2000, I believe it was 17, in the Exxon versus Rincones case, which this court decided, the court there said, it didn't put the standard that way. It said that that the movement has no burden to negate the non-movement's avoidance defenses. So
Right, and so and they were talking specifically there about defenses like estoppel and fraudulent concealment, where the plaintiff is admitting that limitations has run, but says you still can't enforce it because for those reasons. But if you look at Zale and Orem, where we had statutory tolling provisions, we reached the other conclusion and said, if it's absence from the state or prior proceeding that's tolling based on the statute, you don't count those days, that is part of the defendant's burden as a movement on summary judgment to establish that you should or shouldn't count those days. Otherwise, you don't conclusively establish your limitations defense. So if you've got a statutory tolling provision, which is what we had in Orem and Zale and what we have here, then why shouldn't we follow those cases?
Well, in Orem and Zale, those particular tolling statutes had to do with when the cause of action either accrued or when the action was brought. I'm
not sure that's true in Orem, because there it involved taking out the amount of time during which a prior lawsuit was pending, which was in the middle of the statute of limitations. But in any event, even if it was required to be at the beginning, it seems like it seems like really what this statute is doing is delaying the accrual of the claim, because it says it doesn't toll if the unsound mind comes up in the middle of the limitations period. It only tolls if the unsound mind is at the beginning of the limitations period. The statute seems pretty clear on that. And so that being the case, it seems like this is very much like the discovery rule, where the clock doesn't even start until the end of the unsound mind.
Well, the main practical difference between this case and the discovery rule is that in the case of a discovery rule, the way it's been now formulated with its inherent undiscoverability, the defendant, the moving defendant, has some means practically of establishing that fact. That is, they can go out and find evidence of where the plaintiff could have discovered this cause of action. Unlike in an unsound mind case, the plaintiff has no idea. They're talking about a case that applies across civil procedure. It applies to car wreck cases where the plaintiff may have never even known the other side. And they're saying that the statute of limitations is told simply because the defendant alleges, or the plaintiff alleges, he was of unsound mind. And to get a summary judgment, you've got to go back and find the person and find evidence that they were of sound mind back then. And that's an extremely expensive and probably often insurmountable obstacle.
Mr. Monning, I think your opposing counsel agreed that if you had filed a no evidence motion for summary judgment on unsound mind instead of a traditional motion for summary judgment on unsound mind, then he would have borne the burden of putting on some evidence. Why doesn't that resolve the concerns that you're expressing?
Because, Your Honor, a no evidence motion cannot be filed until much later in the proceeding, until there's been, quotes, ample time for discovery. And the issues regarding the tolling, the issues regarding the statute of limitations are facially established when the petition is filed, if they do what they did here, and that is attach a copy of the deed that's being challenged.
It seems like we said the opposite in Zale, though, Mr. Monning, because there we've got a statute that where it is a statute that talks about a limitation suspension statute was the word we used in Zale, that when the plaintiff raises a limitation suspension statute, such as the one for absence from the state, the limitation defense is not conclusively established until the movement meets his burden of negating its applicability. So I certainly understand the concern about the access to proof, but wouldn't it be the same in Zale? I mean, you might not know whether the defendant was absent from the state or not, yet we said the burden lies on the moving party.
Your Honor, you're better conversant with the holding in Zale. The way I recall Zale, that was a holding, you're right, based on the absence from the state, and the court said, I think that's the one that they said that they used the confession and avoidance language to differentiate between the two. I don't see how to reconcile those things with, I don't have a response for your argument on that point right now, other than the practical consequences of the rule you're considering if that's what you decide, because of the reasons that I just explained. It's to distinguish between statutory tolling provisions and what I'll call common law tolling provisions seems to me to be a distinction without a meaningful difference, Your Honor. I'm just trying to survey the estoppel was alleged in, I can't remember if the KPMG case, but I don't see the effect.
It was alleged, but regular discovery rule tolling was too. And we said the general rule that the movement must conclusively negate applicable tolling provisions, but we also said if the movement establishes that the statute of limitations bars the action, the non-movement must then adduce summary judgment proof raising a fact issue in avoidance of the statute of limitations. It seems as though we said there was some burden of production that the non-movement must to raise is more than just to plead. And we are kind of all over the map, but it would seem as though we're resting the ultimate summary judgment burden with the movement, but at least in KPMG, we seem to say that there was some burden of production on the non-movement.
Well, that's correct, Your Honor, and I think KPMG is I think KPMG is interesting for two reasons. Number one, the sentence that the court that you referred to about the burden being on the non-movement to come up with something in avoidance. I think it's also important to, if you're relying on the Jennings case and the Diaz case, as was used to support the Renda decision. Jennings was authored by Justice Baker, and it used the negate all applicable tolling language. Diaz did the same thing. It was signed by Justice Gonzalez. In Rhone-Poulenc, which was decided shortly after KPMG, Justice Baker signed that opinion, and he didn't use that expansive language as he had in Jennings and as Justice Gonzalez had approved in Diaz. He used much more restrictive. I've got the reference cited in our materials in the Rhone-Poulenc case, but he acknowledged that there is a burden that will shift back to the plaintiff. I think Rhone-Poulenc was probably a discovery rule case too. All of these, they got off on this. You've got Oram and Zale, per curiam opinions in the that I think must have thought that Moorburger and Nichols versus State settled the law on the proposition that the non-movement had a burden once the statute of limitations had been facially established. So Oram per curiam cites Moorburger and Nichols, and Zale, I believe, did the same thing, or it may have cited Oram. They didn't distinguish between common law, what I'll call common law tolling provisions, and statutory tolling provisions. It's natural to want to understand exactly what they were dealing with, because I think that is important, but they didn't distinguish between that. And when they moved forward this Wood against Mercer, which was they moved forward to Weaver against Witt back in that same era, and that's really kind of where the problem was created, because in Weaver v. Witt, they said, at that time, the Supreme Court thought the discovery rule was a feature of medical malpractice law. That's what it said in its opinion. And it said, we're going to go ahead and put the burden on the plaintiff to disprove the discovery, on the defendant to disprove the discovery rule in these med mal cases, with a footnote that says, by the way, the discovery rule is no longer going to apply to mid-mile cases filed after a date 2 months before the opinion. So it was, they thought that, I think it's fair to assume that when they did Weaver v. Witt, the Supreme Court thought they were through with the discovery rule because of the legislature's decision. As things happened, the discovery rule remained. We get to Woods against Mercer, and that's where the court reverses itself in this application of this confession and avoidance nomenclature. So the reasoning that in Weaver v. Witt changed, but they left the holding intact. It was a 5-4 decision. We can only speculate as to the importance of that inconsistency in the logic.
Mr. Monning, I'm still not understanding why the question presented by Justice Boyd having to do with the no evidence motion for summary judgment simply wouldn't have resolved the issue.
Well, I never thought about the fact that there may be a different, if the burden is on a party to produce evidence, I never thought there would be a difference between a traditional and a no evidence summary judgment. We believe the burden is properly cast once we have established our limitation defense, which we have done facially, just on the face of their pleading with the date of their deed and the date of the file mark in the petition. We believe that establishes the statute of limitations defense, and that put the burden on them to come up with evidence of his unsoundness of mind procedurally, just as if we had waited 6 months or whatever period of time that the court thought was appropriate for ample time for discovery and filed a no evidence motion.
But you really don't have, the reason that you have to allow a proper amount of time for discovery before hearing a no evidence motion is so that the party who bears the burden can obtain the necessary information from the other party. But as you and your opponent both agree here, only the plaintiff, your whole argument is that you don't have any of that evidence of unsound mind. Only he has the evidence of unsound mind. So I don't see why a trial court would postpone ruling, because that evidence is there. The plaintiff doesn't need discovery to get the evidence that he already has of his own unsound mind. So I don't think the delay factor is really an issue on the no evidence motion point.
Well, Your Honor, I know there is a hesitancy when you walk in immediately after a suit is filed. At least I am instinctively hesitant when you walk in as soon as a suit is filed and say, I've got a summary judgment defense, to move for no evidence where you've got that language in the rule that requires ample time for discovery. And I don't see a reason for a difference between the two summary judgment procedures.
Mr.
Counsel, what's the substantive standard for demonstrating unsound mind, regardless of who has to prove or disprove what? What is it about the person that has to be shown to establish unsound mind?
I don't think this court's ever said what it is, but the conventional wisdom, I believe, is that it's the ability to participate and assist in the litigation. And I believe that's in one of the cases, that may be in the Ruiz and Conoco case, but I think that's the standard that seems to make the most sense to me. But I get back to the notion it sounds like
it's a kind of a fuzzy standard. It's kind of when you see it sort of standard on which people's opinions might differ as to whether a certain person had a sound mind at the time. And in that way, it seems quite a bit different than something like, were you in or out of the state, which is just a fact that if you plead it falsely, you're subject to sanctions because whether you were in or out of the state. But if we just sort of had this nebulous unsound mind concept, just about anybody could claim to have had some sort of, time in the past when they suffered from some some mental incapacity, and golly, I wasn't in my right mind, and it's all just kind of nebulous, which it would seem to make it more difficult to disprove.
I agree.
Any other questions? Thank you, Mr. Monning.
Thank you, Your
Ms.
Honor.
Alexander, I believe you have 6 minutes.
Your Honor. Respondent argues that the burden would be too much on a movement to establish that the non-movement was of unsound mind. But like the discovery rule, in order to meet this burden, the movement can engage in discovery. Further, when it comes to unsound mind, the purpose of the statute is to protect these litigants who are not able to participate or understand the proceeding. And this is only at the summary judgment stage that the respondent would have to meet this burden of proving the individual was of sound mind. At trial, the burden switches back to the non-movement to show that he was of unsound mind. And so while, yes, it is true that the burden could be high for the movement at this stage, later at the trial, it goes back to the non-movement. In addition, respondent discusses the KPMG case, and basically states that in that case, it was different in that the discovery rule, and that the plaintiff, I apologize, and that the defendant was able to get summary judgment by showing that the non-movement, I apologize. In KPMG, the defendant did present summary judgment evidence, which is why that case is distinguishable from the other cases involving the discovery rule. There, the defendant showed that the plaintiff knew about his injury at an earlier time, which is what triggered the non-movement burden. So the non-movement had a burden in that case because the movement had already met the burden of showing or conclusively negating the tolling provision that was applied in that case. In addition, respondent states that there is no real difference between equitable tolling provisions, equitable defenses versus tolling provisions, but there is. When it comes to fraudulent concealment or when it comes to equitable estoppel, the purpose of those is to prevent a movement from claiming statute of limitations at all. Whereas when it comes to a tolling provision, it delays a movement from asserting tolling provision. And so there's a distinguishing factor between those, which is why there was a different burden at summary judgment versus when at trial. And that's true with all of the cases that respondent relies upon. That's when it comes to Nichols, which is related to a estoppel defense or fraudulent concealment as an estoppel defense. And similarly, when it comes to Exxon, which is another case that relied upon by respondent. And there it did not involve a tolling provision, rather it involved an argument that the defendant was equitably estopped from asserting the statute of limitations. Both Nichols and Exxon involve affirmative defenses that prevent a movement from asserting the statute of limitations to begin with. Because the respondent presented no evidence at the trial court level negating the applicability of the unsound mind tolling provision, summary judgment in her favor was improper.
Any other questions? Thank you, Ms. Alexander. Case is submitted and the court will take a brief recess.